In this video, I'm going to discuss the different types of penalties for criminal offences in Queensland. That is state offences as opposed to Commonwealth offences. Absolute discharge is the first one. This is where you are released without a conviction being recorded and without any other penalty. Then there's a Section 190 order. This type of order only applies if a magistrate court convicts you of a property offence. The court can release you without imposing a sentence if you pay an amount ordered by the court. The amount ordered by the court can be for damages and any costs. Then there are bonds, or recognizance orders as they're called. There are various types of bonds the court can impose, which I'm going to discuss with you. The court can set a monetary amount of money if you have to pay. You may have to pay if you breach a bond. There's a Section 19 bond. So the court can sentence you to a Section 19 bond if you were convicted of an indictable offence or a summary offence. There is no conviction recorded for these bonds. The type of bond is where you're released into the community for a period on the condition you agree to be of good behaviour, meaning you cannot break the law. The maximum period of one of these bonds can be for is 3 years. To break the law, you can be ordered to appear before the court to be convicted and sentenced. Besides being of good behaviour, the court can impose other conditions, such as requiring you to attend a drug education session. Then there are what we call Section 21 bonds, and they're for property-related offences. So when you're being sentenced for a property-related offence, the court can adjourn your sentence hearing up to 6 months, subject to you entering a bond. The bond requires you to appear before the court to be sentenced at a stated date, or if you're called on earlier by the court to do so. Conditions of the bond can include requiring you to give back property subject to the charge to the person who lawfully owns it, restore property subject to the charge, pay compensation to the person who has suffered because of damage they caused to the person's property. Then there is Section 30 bond, recognizance, conviction on indictment. If you are convicted on indictment, that is, in the District or Supreme Court, you may be sentenced to a bond to keep the peace and be of good behaviour for a fixed period. The bond can be in addition to any other penalty imposed by the court. You can be imprisoned up to 1 year until you have entered into the bond. Then there are Section 31 bonds. If you are convicted summarily of an offence, you may be sentenced to a bond to keep the peace and be of good behaviour for up to a period of 1 year. Then there are fines. Now, a fine is a monetary penalty decided by the court. The court will give you a time to pay the fine. In deciding the amount of the fine, the court must consider your financial circumstances. Fines are often referred to the State Penalties Enforcement Registry, which is commonly referred to as SPER, and they're a government agency who collect the money on behalf of the government. A conviction can be recorded if the court gives you a fine as a penalty. The court can give a person one fine for multiple offences. Now, I'm going to talk to you about probation. A probation order is referred to as a community-based order. This means the order allows you to remain in the community as opposed to being sent to prison. Courts can use a probation order as an alternative to a prison sentence or with a prison sentence. This means you may be sentenced to a term of imprisonment, and when you are released from prison, you are subject to a probation order. If you are sentenced to a probation order, you'll be supervised by the Department of Corrective Services in the community. The court can only make a probation order if a person is sentenced for an offence punishable by imprisonment or for a regulatory offence. A probation order can only be made if you agree to the conditions of it. The magistrate or judge will read out the conditions of the order and ask if you agree to abide by them. The probation order will be for a defined period. If you are not sentenced to a prison sentence and probation, then the minimum period the order can be for is 6 months and the maximum is 3 years. If you are sentenced to a prison sentence and probation, then the minimum period of the order is 9 months and the maximum is 3 years. Now, you might be wondering, is a conviction recorded for a probation order? If the court makes a probation order, the court does not need to record a conviction. So, what are the conditions of a probation order? The mandatory conditions of a probation order are: you must not commit another offence. You must report to an authorised corrective services officer at the place and within the time stated in the order. You must report to and receive visits from an authorised corrective services officer as directed by that officer. You must take part in counselling and satisfactorily attend other programs as directed by the court or an authorised corrective services officer during the period of the order. You must notify an authorised corrective services officer each time you change your home address or where you work, and this must be done within 2 days after the change has been made. You can't leave the state of Queensland without the permission of an authorised corrective services officer. And you must comply with every reasonable direction of an authorised corrective services officer. The court can include any other conditions it thinks fit in order to try to cause you to behave in a way acceptable to the community, prevent you from committing the same offence for which you were sentenced to the probation order for, to prevent you from committing more offences. If you have mental health issues, the court may make a condition for you to complete counselling with a psychologist or psychiatrist. Now, what happens if you breach a probation order? If you do not comply with the probation order and you do not have a reasonable excuse, you can be fined. In addition to being fined, you can return to court and be sentenced for breaching the order. This can involve you being resentenced for the offences for which you were originally placed on the order. This means the court will give you another penalty. When resentencing you, the court must consider your compliance with the probation order when deciding on the new penalty to give you. Now I'm going to move on and discuss another community-based order, being community service orders. A community service order requires you to perform unpaid community service within 12 months, unless the court provides a different period. The order has to be for a minimum of 40 hours, and it can't be for more than 240 hours. The court can only make the community service order if you are being sentenced for an offence punishable by imprisonment, or you're being sentenced for a regulatory offence, and you agree to the order being made. Now, you may wonder, is a conviction recorded for a community service order? The court doesn't need to record a conviction for a community service order. You may wonder, what are the conditions of a community service order? Well, I'll explain these to you now. The conditions are: you must 1. Not commit another offence while on the order. 2. Report to the Corrective Services Office stated in the order and by the time stated in the order. 3. Report to the Corrective Services Office as and when directed by an authorised Corrective Services Officer. 4. Receive visits from an authorised Corrective Services Officer as and when directed by that officer. 5. Perform the community service in a satisfactory way as directed by an authorised corrective services officer. 6. Notify the authorised corrective services officer if you change your residential address or change jobs within 2 days of the change happening. 7. You must not leave Queensland without the permission of an authorised corrective services officer. And 8. You must comply with each reasonable direction of an authorised corrective services officer. If you are sentenced for more than one offence, the court can make more than one community service order. However, the total number of hours the court orders, when added together, cannot exceed 240 hours. When does the community service order end? A community service order ends: 1. If you complete the number of hours of community service stated in the order. Or 2, if you were sentenced for further offences for which the order was made. 3, if the order is revoked. Now, what happens if you do not comply with the community service order? It's an offence to contravene one without a reasonable excuse. You can be fined. However, besides being fined, if you don't comply, the court can revoke it. If the court revokes the order, the court can re-sentence you for the offence for which they made the order. Now, when the court re-sentences you, it must consider how much you complied with the order in deciding what new penalty to give you. I'll now move on and discuss intensive correction orders, often referred to as an ICO. If you're sentenced to a term of imprisonment of 1 year or less, the court can make an intensive correction order rather than sending you to prison. This means you serve the term of imprisonment in the community and you're subject to the order for the time of your sentence. The Corrective Services Office or Probation or Parole Office supervise you in the community while you're subject to the order. The order is like a probation and community service order combined. If you are subject to an intensive correction order, you can expect to report to probation and parole at least 2 times a week, report to and receive visits from the probation and parole officer, attend programs and or counselling as directed, and complete up to 12 hours community service each week as directed by the probation and parole officer. If the court makes an intensive correction order, it must record a conviction. An intensive correction order can only be made if you agree to it being made. So what happens if you don't comply with an intensive correction order? If you fail to comply with the intensive correction order, the court can revoke it, and you can be ordered to serve the balance of the remaining time in prison. Now, I'll discuss suspended terms of imprisonment, known as suspended sentences. If the court sentences you to a term of imprisonment of 5 years or less, it can suspend part of it. That's known as a partially suspended sentence, or all of it, known as a wholly suspended sentence. If the court suspends part of your sentence, this means you will serve some time in prison. If the court wholly suspends your sentence, meaning all of it, then you will not go to prison. When the court sentences you to a suspended sentence, it must set an operational period. This is the time, it's either expressed as months or years, you must not commit any offence punishable by imprisonment. If you commit any offence where imprisonment is a potential penalty during your suspended sentence, you'll be in breach of the order. What happens if you commit an offence punishable by imprisonment during the operational period of a suspended sentence? If you commit any offence punishable by a term of imprisonment, you will breach your suspended sentence. If the court sentences you for breaching a suspended sentence, the starting point for the court is to order you to serve the whole of the balance of your suspended sentence in prison. The caveat for this is the court is not to make such an order if it would be unjust to do so. There are various factors the court must have regard to when deciding if it is unjust to order you to serve the balance of your suspended sentence in prison. The law says when a court decides if it would be unjust to make you serve the balance of your suspended sentence in prison, it must take into consideration the following things. 1. Whether the new offence is trivial when considering the nature of the offence and the circumstances in which it was committed, the proportion between your culpability for the subsequent offence and the consequence of activating the whole of the suspended sentence, imprisonment, your antecedents and your criminal history, the prevalence of the original and breaching offences, anything showing that you've made a genuine effort at rehabilitation since the court made the suspended sentence. For example, have you been out of trouble for a long time while on the suspended sentence? If you've completed any community service, if you've paid any fines, compensation or restitution, and anything in a pre-sentence report. The degree to which you reverted to criminal conduct of any kind, and your motivation for committing the breaching offence. 2. The seriousness of the offence you were placed on the suspended sentence. This includes any physical or emotional harm caused by you to a victim, any damages, injury or loss you caused as a consequence of committing the offence. 3. Any special circumstances that was not present at the time you were sentenced to the suspended sentence that may make it unjust to order you to serve the whole of the balance of the suspended sentence. Now I'm going to discuss imprisonment with actual time imprisonment, actual time in custody. If you're sentenced to a term of imprisonment which isn't suspended, the court should set a parole release date or a parole eligibility date. Parole release date is a certain date you'll be released from prison, whereas a parole eligibility date is a date when you're eligible to apply for parole to be released. So you apply to the parole board to be released on parole. Unlike a parole release date, there's no certainty as to when you'll be released from custody. So when can you get a parole release date? If you are sentenced to a term of imprisonment of 3 years or less, and the offence isn't one of a sexual offence or a serious violent offence, the court can set a parole release date. So when can you get a parole eligibility date, or when must the court make one? If you are sentenced to a term of imprisonment of more than 3 years, and the offence is not a sexual offence or a serious violent offence, the court must set a parole eligibility date. If you are sentenced to a term of imprisonment for a sexual offence or a serious violent offence, the court must set a parole eligibility date also.